I mean, there was a lot about color when we started out. There was a lot about color. It was more behavioral. The great. I have a 21-year-old son. I found like the same age as me. I have a boy.
I would ask Commissioner Deskovich if she would please lead us in the Pledge of Allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
commission meeting. The parties cannot renegotiate and present a new stipulation at this meeting, nor can the commission negotiate a new stipulation. All right, complainants have the right to respond in writing to proposed stipulations. We have not received any comment from the complainant in this case. Are there any members who need to make a disclosure in this matter? And if so, please state that for the record at this time. All right, hearing none, Ms. Miller, you are now recognized to present the amended stipulation.
Thank you. Commissioners, some of you may remember that initially this respondent signed an agreement that called for a civil penalty of $3,500 and a public censure and reprimand. The commission rejected that stipulation, so what you have before you is the amended stipulation, whereby the respondent agreed to a civil penalty of $10,000, which at the time was the maximum penalty, and a public censure and reprimand by the governor. The respondent no longer serves in the public position for which this violation arose. And I ask you please to approve this amended stipulation. Thank you.
Okay, are there any questions from the members?
Second.
All right, all in favor? Aye. All right, the amended stipulation is approved. Moving right along. Okay, moving on to item number 6 is another consideration of final action on a joint stipulation. This is a proposed settlement and complaint number 22-065 in Ray Orrin Miller. Will the parties or their counsel again please identify themselves for the record?
Mark Hammond on behalf of Orrin Miller.
Elizabeth Miller, advocate for the commission.
All right, probable cause was previously found in this complaint as well, and now we have before us a joint stipulation between the commission advocate and the respondent. After considering all the materials, the commission may vote to approve or reject the stipulation. And if rejected, the parties cannot renegotiate and present a new stipulation at this meeting. Okay. I just want to make sure. The complaint would go to the Division of Administrative Hearings for an evidentiary hearing, or the parties could negotiate a new settlement for consideration at another commission meeting. Complainants have the right to respond in writing to proposed stipulations. We have not received any comment from the complainant in this case. Any members of the commission who need to make a disclosure regarding this case? All right, Ms. Miller, you're recognized to present the stipulation.
Thank you. This respondent served as a Sumter County Commissioner from 2020 until he was suspended by the governor on January 6, 2022 for perjury. At that time, he created a GoFundMe account for the purpose of offsetting his legal fees and legal expenses defending himself against the perjury charge. On some occasions, he filed the appropriate CE Form 9, which is the gift disclosure form, and sometimes he didn't file it. The problem is his forms were either inaccurate or untimely. Probable cause was found for 3 violations in this matter. The first violation is for failure to timely file a CE Form 9 for the 4th quarter of 2021. Respondent has agreed to pay a civil penalty of $1,000 for this violation. Second violation is for failure to file a CE Form 9 for a donation received during the 1st quarter of 2022. He has agreed to pay $1,000 for this violation. The third violation is for failure to file an accurate CE Form 9 in June 2022. And again, respondent has agreed to pay a $1,000 fine for a total of $3,000. In lieu of a formal hearing, Mr. Herron and I request that you adopt the stipulation. Thank you.
Are there any questions from the members for Ms. Miller? Commissioner Newton.
Just for that. Is it me or does it seem habitual, like it's a pattern?
This was a very unusual case in that applied to a GoFundMe account, and I think the respondent was probably confused, but Mr. Herron can address that better than I can. He did try to file, but didn't meet all the criteria for filing accurately. So it was a lot of money came in at one time, and he should have filed more timely, but did not. He left some donations off also.
Any other questions? Mr. Herron?
Mark Herron on behalf of Orrin Miller, and to address your question as well as for the new members of the commission that weren't around when this case was presented at probable cause. From Mr. Miller's point of view, this case turns on when he accepted the GoFundMe contributions. It's the commission's position, and it has been in this case as well as other, that you accept the GoFundMe contributions when it is made to the GoFundMe account. Mr. Miller's understanding was you accept the money when you withdraw it from the GoFundMe account. That was the basis of the probable cause finding. It's a timing issue. That's why, on behalf of Mr. Miller, we would urge you to adopt this joint stipulation. It's not really a pattern. It's an understanding of contributions that were given in 3 separate quarters, when they were given versus when they were accepted. And we'd ask you to adopt the joint stipulation. Thank you very much.
Commissioner Newman?
Being a former representative, we all get online donations. And every donation we get, be it GoFundMe, fundraiser, or whatever, has a date. And if it comes in within that window, that date of that reporting period is to be submitted. The only thing I know of that requires a date of reception is when you get a check. If you give me a check, it can be dated in June, but if I get it from you within that reporting period, that's when I report it. So, for us, online has always been that way since the beginning, so I don't understand the misunderstanding. I think that's clarified in the election financial portion of the book and the oath itself.
We had this discussion, you and I, when this case was here at probable cause. And the point that I hoped I had made that time and I'm going to try to make now is the GoFundMe account that we're talking about has nothing to do with his election. This is not an election issue. It's not a campaign finance issue. It's a GoFundMe account that was established to pay legal fees. And again, Mr. Miller's understanding or belief at the time was that he only accepted the money when he moved it out of a separate GoFundMe account into his account. And that created the reporting violations that are before you.
Hello, Madam Chair. Is Mr. Miller elected official?
Pardon me?
Is he elected official?
He was. He was a county commissioner in Sumter County.
So he understands about electronic donations and reporting?
Again, if you're talking about campaign contributions,
No, I'm talking about.
okay, again, I've said it 3 times.
Elected official receiving funds, you have to document that and disclose that. That's why we're here.
I understand what you're saying. What Mr. Miller's understanding was during these periods is that he did not accept the monies until he had the opportunity to move it from the GoFundMe to his personal account. And there was a possibility, and again, it's in the report of investigation, that he could return those monies prior to the time he moved them. And so from Mr. Miller's point of view, he never accepted those donations until he moved them.
One question, Madam Chair. During this campaign, let's be hypothetical here. He got electronic contributions. When did he report those? Did he report those when he got them or when he took them out?
His campaign contributions issues are not before this commission.
No, I guess I'm getting a little confused. My problem is this. He's claiming ignorance to the timing of taking funds out when if he did that during the campaign, he knows that when that money comes in, it has to be reported. That's where I'm going. I'm not trying to get to his campaign finance. But if he's gonna plead that, I wanna know historically, did he do the same thing with his campaign funds? That's all. Because if he did, then I understand what the argument is. But
Well-
if he didn't, this is an argument of convenience.
I'm an election lawyer too, okay? And you cannot accept campaign contributions through a GoFundMe account. Can't do it. You have to accept them by the campaign treasurer, and they have to go in your campaign account. So there's no way to make an analogy between the two.
Well, Madam Chair, the analogy is electronic contributions. When they came in, we need to be reported. Be it GoFundMe, like I said again, fundraiser or whatever. That's what's at stake here. And the understanding is that he understood, and this is from your testimony, that when he took the money out is when he's supposed to report it, not when it was actually donated, when it was supposed to be reported.
And that's what he did. He reported them when he took it out. The issue became, should he have filed reports earlier in the other two periods when the monies were contributed? And again, that's the issue in this case.
Thank you, Madam Chair.
Madam Chair, if I may, I know I'm new and no background to the story, but as someone who's served as an elected official and raised money through campaigns at a local election, I think sometimes state representatives and others have access to more information, but I do recall receiving PayPal donations, and I had a treasurer that handled that, and she was always very confused, and we read the campaign handbook many times. It was never clear on when she was supposed to report that. It was always maybe it's more clear now, this was 2016, but it was always very unclear. But not only that, if I had a GoFundMe for something post that, I don't think I would have a treasurer handling that, and so now it would be on me to know maybe what she did and what she was trying to handle. I just remember constantly her saying, the PayPal wasn't moved over yet, so I didn't report it, so I reported it the following month, and so it's always very confusing of when you have that money in your hands.
PayPal is an authorized vehicle or conduit through which a campaign can accept money, okay? It's a PayPal account that's related to the campaign directly. You are correct that there is a delay in the money moving from the PayPal account, could be an ActBlue account, could be an Anodot account, whatever it is, over to the campaign. The Division of Elections has taken a position with respect to that money is to be reported when it's put into the PayPal account. Okay, that's my recollection. But again, it was Mr. Miller's understanding with respect to this account, because he never took it out of that account, and he had to make that decision to do that it was not accepted by him until it happened.
Is it fair to say that the parties think that there was a good faith misunderstanding that mitigated the wrongdoing, and that's one of the reasons why this joint stipulation was crafted the way it is?
Mr. Miller, through me, has conceded to the Ethics Commission's position on this issue. You've met it, you've referenced it in other cases. For example, even in the Underhill case, you've referenced it in that case. The money is in the account when the contribution is made. Or it's reportable, I should say, when the contribution is made.
Trying to help you. Are there any other questions? Sure.
You have follow-up time, right? I don't want to get you in trouble. You say some time for follow-up.
I'm sorry, sir?
Save time for follow-up. I don't want to get you in trouble.
Oh, yes, sir. Save time for rebuttal or follow-up, please.
What's the max fine for each offense?
$10,000.
$10,000.
Yes, sir.
He's willing to pay $1,000.
Yes, sir.
Thank you.
Thank you.
All right, any other questions? Is there a motion to adopt the stipulation?
So moved.
Is there a second?
Second.
All right, all in favor? Aye. All against? All right. The motion passes. Okay, thank y'all. Okay, item 7 is consideration of final action on the advocate's motion to dismiss the complaint in case number 17-180 in Ray Woodrow J. Latvala. Recognize Commissioner Gates if you needed to make a disclosure.
Thank you, Madam Chair. I wish to make a brief statement in the nature of the statement I made when this matter came up before us before. I've had a discussion with our general counsel, and he's advised me that by authority granted by Section 286.012 of the Florida statutes, A member of a collegial body such as ours can abstain from voting and participating in a matter to assure that its quasi-judicial proceedings are fair and appear to be fair to the parties and the public. The respondent in this case and I served in the Senate together, and we had a contentious relationship. And so in fairness to the respondent, and in order to maintain a fair proceeding, in the appearance of a fair proceeding, I will abstain from consideration of this matter.
Question? I just wanted to be clear, Commissioner, you're doing this voluntarily. He is not required, maybe through counsel, he's not required to abstain in this matter, but he's doing it voluntarily?
Through the chair, Commissioner, that's correct. An abstention under section 286.012 is discretionary. When you are abstaining in a quasi-judicial proceeding to maintain the fairness or the appearance of fairness, it's the last sentence in the provision of 286.012.
Okay.
You recognize?
I have a disclosure. I served in the Florida House when Senator Ladell served in the Senate, and we also have some hidden relationships outside of the House that he assisted in, and but it won't affect my vote. But I want to disclose that it's known.
Madam Chair, may I make one observation? I don't want to unnecessarily belabor the decision by Commissioner Gates to abstain, but because it was part of our package to review the supplementally filed motion to disqualify, I felt like it's important for the record to address a question that I have because it referenced an affidavit from.
Should we move to consider that motion then?
Oh, is that still going to be considered?
Yes.
Once again, 2 mistakes in 30 minutes. I thought that his abstention would be a way of addressing that, but I apologize.
And I'm sorry to interrupt.
Thank you for interrupting.
All right, counsel for respondent timely filed a motion to disqualify Commissioner Gates from participation in the consideration of this complaint. An affidavit stating the particular grounds for the request accompanied the motion, and under Rule 34-5.017 of the Florida Administrative Code, commission members shall be disqualified from sitting as a member of the commission at either the probable cause hearing or final public hearing for bias, prejudice, or interest if the motion and affidavit are found legally sufficient. The motion must be ruled upon by the commission member whose disqualification is sought. So I'll recognize Commissioner Gates again on this.
Thank you, Madam Chair. Counsel for the respondent has filed a second motion to disqualify me from participating. I've reviewed the motion and the affidavit that's attached to it. I've consulted with our general counsel, who's informed me that under Rule 34-5.017, parent 3 of the Florida Administrative Code, I am the person who must rule on this motion, and my ruling shall be based on the legal sufficiency of the motion and the attached affidavit. And given, Madam Chair, that I've already abstained from this matter under Section 286.012, as I mentioned earlier, I find the motion is moot, and therefore I deny the motion. Thank you, Madam Chair.
May I ask a question of these? So the language of the rule only requires the granting of a motion at a probable cause hearing or a final public hearing, and this is neither of those, right?
Well, this will result in a final order. This is potentially a final hearing in that where this is a request for a dismissal. It is a quasi-judicial proceeding, so the original extension is entirely correct. And as far as the recusal goes, the motion for recusal is it's appropriate for them to make it for this proceeding because it could result in a final order.
Okay. All right. Okay, so now we're moving on to the motion to dismiss then.
May I still
Oh,
comment
sure.
on that? And again, I really am belaboring it now, for sure. But it just bothers me when I see something that's an affidavit that is attached to the motion to disqualify, and since we were he is ruling on it, not us, but it's part of our package and part of the record. And this may be a question more appropriate for his counsel and maybe it doesn't need to be addressed at all if I've read it incorrectly, but the affidavit is addressed in the motion to disqualify, and it's attached and incorporated into the motion, and it references the affidavit recognizes quotes made in a Politico article that was dated November 3rd of 2017. And if I read these, as I think I read them a couple of times, that Politico article quotes Matt Gaetz and references Senator Latvala being a hound and his treatment of women being adverse, and then that is then picked up and attributed to Senator Don Gaetz in the affidavit. So I just think that there is a wrongful attribution in an affidavit that's attached to a motion to disqualify that's now a public record, and to me that deserved addressing.
Thank you.
If the commissioner abstained himself, that was the intention of the motion, and get him not to participate. He already volunteered not participating, so through legal, if I could, what are we doing? I mean, he's not participating. So whatever
Sure.
motion that was filed, as if it's been satisfied, because he didn't want to participate, now he's not participating. So I don't understand.
Right. I think the motion was denied. I had a wonky legal nerd question, and I think that was just a clarifying comment for the record, but I think we can move on.
Legal, if I could, Madam Chair.
It's clarifying, but I again think that it's a substantial attribution, and I don't think this is an environment in which people are going to be able to change. We don't accept sworn testimony, but because it was a sworn affidavit and it is a key point of the evidence that was used by the respondent to disqualify a commissioner, again, that's why I think it's worthy of highlighting.
Through the chair, to answer your question, I think we're all in agreement that the abstention provides the remedy requested, or maybe we're not all in agreement, but I am of the opinion that the abstention grants the remedy requested in the motion. I'm not aware of a situation where we would grant a motion when the remedy is already present, and so I think the denial for mootness is appropriate, and having done that, I think that the next steps are, of course, to address the merits of the motion to dismiss.
Thank you, sir. Thank you, Madam Chair.
All right, if the commission grants the advocate's motion to dismiss, the matter would be dismissed. And alternatively, if the commission denies the motion, the case will proceed to the Division of Administrative Hearings for an evidentiary hearing, or the parties could reach a settlement. After the vote on this motion, we'll proceed with the complainant's request for withdrawal. All right, will the parties or their counsel please identify themselves for the record?
Good morning. Ryan Andrews on behalf of Jack LaFalle.
Elizabeth Miller, advocate for the commission.
All right, you may proceed.
Thank you. Commissioners, I'd like to first summarize my motion that's before you. In this case, there are two critical witnesses. Both the witnesses did not want to testify. One witness is Rachel Perrin Rogers, and the second witness is Laura McLeod. They both alleged sexual harassment. Rachel Perrin Rogers has repeatedly refused to testify, and Laura McLeod has expressed her reluctance to participate. With their testimony, I believe that we could substantiate the allegations. Without their direct testimony, we're left with inadmissible hearsay. That's the evidence we have right now. In light of the circumstances, I regrettably request that the complaint be dismissed. Thank you.
Any questions from the members of the commission?
I move the cabinet's recommendation.
No, I had some questions first, Commissioner.
Please do recognized.
This is not an uncommon problem that prosecutors have, reluctant witnesses failing to show up, yada, yada, yada. If you assume that you went forward to a DOA hearing, what remedies, if any, do you have to compel attendance or to address non-attendance?
Through the chair, I could go to circuit court to compel their attendance or ask that they be held in contempt. However, due to the facts of this case, the sensitive nature of it, if the witnesses did not want to appear even under subpoena, I was reluctant to move for a contempt. But I could.
I understand your reluctance, but that is an available mechanism. Second question, I sense from what you were saying that the second lady is reluctant, but not necessarily as adamantly refusing to appear as the first?
Again, through the chair, she was not ever subpoenaed to appear. She would have appeared to testify had she been subpoenaed. Through her lawyer, however, she asked not to participate.
I understand, thank you.
Any other questions?
I have one.
Go ahead.
I just want to be clear on I'm still on the abstention. There's no precedent being set here by a member of this commission abstaining on an issue that would hold going forward because we worked with someone, served with someone, didn't get along with someone, for whatever reason. That's up to us as individual commission members to make that determination as to whether we abstain or don't abstain on an issue?
That's correct. So to clarify what has occurred here, there's two different things that's occurred, and so I'll explain them both because they're different. The first thing that's happened here is there's been an abstention under section 286.012, which is, I'm going to pull it up. Bear with me a second. I will just pull that statute up and I'll just read what it says because I think that would clarify what is occurring here and why it's important that it occur. Bear with me just a moment. All right, section 286.012, when you look at it, it's a long paragraph. In 2014, they amended it to add a provision to it to allow for an abstention in a circumstance kind of like this. Now, if you look at the motion to disqualify where it quotes section 286.012, the motion conveniently leaves out this section, quotes a bunch of Attorney General opinions and Commission on Ethics opinions from 2011 and earlier before the 2014 amendment was made. So if you're judging all this by the motion to disqualify, you'd be missing a substantial important piece of the law. The last sentence, what it says here is, if the official, so taking you through 286.012 from the beginning, the first sentence of it is, if you're on a board, you have to vote. The second part of it says, if you have a conflict of interest under certain provisions of the Code of Ethics, you cannot vote and you must follow the voting conflict remedies under section 112.3143. If you have the appearance of those conflicts, you may abstain also in those circumstances. Then it says, if the official decision, ruling, or act occurs in the context of a quasi-judicial proceeding, a member may abstain from voting on such a matter if the abstention is to assure a fair proceeding free from potential bias or prejudice. In a situation where there is the potential for bias or prejudice, any of you may, on your own discretion, abstain from the matter. And I think that it's important to understand why we do that, especially here at the Commission on Ethics, where we don't want our proceedings, our quasi-judicial proceedings, to be tainted by bias or prejudice or the appearance of bias or prejudice. In an act to protect the image of this commission, a commissioner may abstain for that reason. That's been done, and that takes him out of the consideration of this matter, like it did the last time that this matter appeared.
Right.
Before, I guess, maybe a week ago, or I don't have the exact date, we received a filing for a motion to disqualify, as we did the last time that this matter came before us for the stipulation and the pre-probable cause stipulation and the probable cause hearing. The motion is judged on the legal sufficiency. The motion states a bunch of facts and then requests a remedy that he disqualify himself. He's already not participating in the matter. There isn't anything else that he can do to grant it. The remedy is moot. And so the motion is not legally sufficient in that there's nothing to be done. So those are the mechanics going on. Do you have any additional questions about it?
No, I was just concerned about moving forward, certainly, excuse me, Chair. Commissioner Gates would always act for the betterment of the commission. I have no question about that, and it does clear the air, per se, on discussion and consideration of this matter. I was just concerned about setting a guideline moving forward. Certainly, all of us have people that we've interacted with that perhaps didn't interact, like we're in church on Sunday, and it just, I needed the clarification, and essentially it would be up to us to make that declaration at some point in time, if it was not obvious, that here, and explain here is why I am recusing myself.
There seems to be some agreement between the person making the request for the motion to disqualify and the person who gets to rule on it, in that they both agree that at least for the appearance of a fair proceeding or bias or prejudice, his non-participation is appropriate. They both seem to agree on that, so that's not really, it doesn't appear that that's a dispute.
Okay, thank you.
Mr. Andrews, would you like to make a brief statement on the motion to dismiss?
Good morning. On behalf of Ms. Oladvalo, obviously we join in the motion to dismiss. I think it's clear for a few reasons beyond what the advocate has stated as to why the dismissal should be granted. First, and she used their names, I will too, Ms. Perrin-Rogers has had the ability to testify several times. She's been subpoenaed through her attorney and she wouldn't show up. And I don't know if this is known to the commission, but the Senate's been paying Ms. Perrin-Rogers fees. So it's not like this has been a big inconvenience for her. She's had the ability to have an attorney advise her. The Senate's paid their fees. We've worked through that lawyer that was being paid by the Senate, and she didn't show up. And I think in the record, there's a transcript from the last deposition with her counsel, and we asked her specifically, I think I did, do you have any reason to believe that she would comply with a subpoena in the future if she was ordered by a circuit court? And her lawyer stated in sum, I have no reason to believe that she will comply with a future subpoena or an order. Right? And I think the one disagreement we have is probably why these people may not want to participate. I think that when we've put this in the record before, but just for the new members on the commission, every time there was an allegation from Ms. Perrin-Rogers that involved witnesses, corroborating witnesses that she alleged, no witnesses corroborated her testimony or her allegations. In fact, they said the opposite. They said it didn't happen. For the ones where there were no witnesses, we've submitted documentary evidence that was not available to the special master for purposes of his report, which is the basis of the complaint that was before the commission. We submitted his cell phone records, which shows that, for example, on the...
Chair, excuse me, I object to this. We've already had a probable cause hearing where the facts were presented. We're here now on the motion to dismiss.
Understood. You could be brief.
Sure. Just trying to recap just part of it. But look, I mean, the fact of the matter is these women don't want to testify for whatever reason. Perhaps if this had not been 5 years later that it showed up for a probable cause hearing and had been closer to the allegations in time, perhaps it would have been different. The idea of we should order them to be compelled when perhaps, in 2018 or 2019, if this had become before this panel, had been voted on and we had a hearing, perhaps they would have testified. But after all these years, there is more than sufficient basis and reason for this commission to adopt the motion to dismiss in this case.
Any questions from the members?
I just have a quick question. Why did it take 5 years? Is that standard operating procedure?
I can, through the chair, give sort of a brief summary. At the time that this complaint was filed at the end of 2017, there were a number of different investigations and things going on with it. The commission waited for other investigations to complete. waited, as I understand it from previous directors, seeing if any other alleged victims would surface, and then obtained the records from the other investigations, which were voluminous, went through those and prepared to begin interviews, and then COVID happened. This was not a kind of investigation that could be done over the phone. So there were a number of delays, unfortunately.
If I may, through the chair, I would say that I think one of them was an FDLE investigation, and to my recollection, that resolved in 18 or 19. It was prior to COVID, but I don't know the specific date or year, but it was certainly before 2020.
Commissioner Simone, did you have a question?
Mr. Andrews, as opposed to the things that you're suggesting about non-cooperation, have either of these women formally recanted their accusations?
Based on the objection, I think, by the advocate, I think I have a different view on whether some of them have changed their testimony or have told other people things that are things that are different than what they have stated to the special master or during this investigation by the commission. I don't think I'll have any agreement on that, but we didn't get a chance to get to those witnesses because we're going to start off with both of the women, and when they didn't testify, no more depositions occurred.
Does that mean that?
No, I don't think it means, sorry, to answer your question directly, no, I think there have been contradictory statements made by at least one of the women, but we didn't get a chance to explore those because they didn't testify.
A contradictory statement, but not in a formal context, like a written, an affidavit, anything of that sort.
Well, it depends. So if you look at what's in for example, the advocate's recommendation and the report of investigation, there are things that are in there, for example, that as it relates to Ms. McLeod, she gave statements to FDLE that said, there was in the news, there was no quid pro quo, nothing untoward happened. But then I think in the report there are contradictory statements there.
I understand impeachment by contradictory statements and all that.
Okay.
Cross-examination material you might have.
Yes, sir.
There is no recantation, Ms. Miller.
Ms. Miller, please.
The recantation, as you know, has to come from the witnesses.
Right.
No, sir, there has been no recantation.
Thank you.
Any other questions?
I do. I don't know that it's exactly a question unless you have some evidence. I was concerned and bristled really by your comment earlier that the first witness you referenced, for whom I'm extremely sorry they have been put through this much time for whatever the reasons were, but you said she hasn't been inconvenienced. And that makes me think that the respondent or the respondent's counsel is tone deaf to exactly the situation that she has been placed in by this behavior that is uncontroverted. But I think I heard that in your argument just now, that she hadn't been inconvenienced. And you may have meant it with respect to how she's been called to testify and her fees being paid. But I feel like, even though I do not know who this woman is, that it's far from the truth.
If I may respond.
Please.
First, I only disagree with one part about her allegations being uncontroverted. I think we've adequately rebutted that. But when I said that she wasn't being inconvenienced, I meant we worked with her attorney to find dates and times that were perfect for her. It didn't cost her any money to have to go through this process of reviewing documents prior to her depo. She had a lawyer advising her and informing her on the process and what she needed to do. I'm not speaking about like underlying allegations and stuff like that. I mean in trying to set her deposition and bringing her to testify to be able to answer to some of these allegations, she wasn't inconvenienced in that way. I think one time two times she didn't show up. Once she had a dentist appointment in Jacksonville, is my recollection. And so we worked around that, trying to reset it. That's what I mean. It wasn't like a one and done, well, you didn't show up and that's that. And we're going to come back to the commission and say you just didn't want to participate. We tried to give her adequate time, adequate ability to testify. And again, it speaks to the financial aspects of it. For example, I could understand if a witness was like, look, I have to testify for 3 or 4 days. I can't afford a lawyer to advise me and be there to defend me and protect me. That would be an inconvenience for the witness, certainly. But that's the vein that I meant it in, Commissioner Akers, not as like an insult as it relates to underlying allegations or anything like that.
Any other questions? All right, is there a motion to adopt or reject the advocate's motion to dismiss?
Move to reject.
Excuse me, Madam Chair.
I'm sorry,
This is a motion.
There's somebody made one from
Move to
down here.
reject.
it was a motion to reject?
Reject.
It's a substitute motion, I think, because it's a substitute, just a point of order. Is that a substitute motion? I think the motion is second, and then there was questions. So we got where we are.
Was there a previous motion?
Through the chair, I believe Commissioner Newton made a motion to accept, and I seconded. Discussion.
We're speaking,
That's how we-
it's to the same effect. It doesn't-
Okay. There was a premature motion made before the respondent had an opportunity to say so. What I'm hearing is that there is a motion to reject. Is there a second? Okay, I don't hear a second on the motion to reject the dismissal. Is there a motion to accept the recommendation of a dismissal?
It still stands.
Okay,
Am I
yes,
correct?
so yes. And is there a second?
I'll
Yes.
second it.
Okay, all in favor of accepting the recommendation?
Can we have a discussion?
Yes.
So the motion is to accept the recommendation.
motion is to accept
and it's
the
been seconded.
recommendation.
Okay. Yeah, I just would like to hear if there's anybody
Okay.
who
Is
wanted
there
to
any
have
discussion?
discussion on it.
I'd like to make it clear why I cannot support this. The behavior in question is, to me, extraordinarily egregious. The respondent is extraordinarily public in terms of being a figure well-known to anybody who pays any attention to legislative matters, statewide and certainly in his own community. The passage of time alone, and unfortunately, in my view, the unwillingness to a large degree of these two women to cooperate, to me, should not entitle somebody to escape judgment for these allegations, and I think we would be remiss if we allowed that to happen. For that reason, I think it should go to a hearing and we see what happens, and our advocate has the ability to take legal steps to procure the presence of those folks and see what happens.
If I may, through the chair. Again, the position on accepting the advocate's recommendation is strictly based on not the substantive matters of the case, which are shocking and unacceptable, but it's the lack of tools the advocate will have to prosecute the case. And the tool that you do have is a double-edged sword, compelling somebody to testify in these matters. With my law enforcement background and now as an attorney, I've unfortunately encountered a lot of these issues where you come to a crossroads. So it's not to the extent that justice is not deserving. It's just the tools necessary to get there are just not available. Thank you.
Commissioner Newton.
I just want to make a statement. My reason for accepting the applicant's recommendation is her testimony alone. And what I'm hearing from you, Commissioner Colby, the women have already been victimized. So the only tool we have, if they don't want to testify, is to victimize them again with contempt. That's the reason, after the advocate got through speaking, that's the reason I accepted her motion. It's been, 6 years, I think it is? I wasn't here when it started, but the only tool we have is to hold those women in contempt.
Not necessarily. If I understood everything, there's at least a possibility that the second woman will come forward.
Any further discussion?
I'll have just one, just because I think the topic is worthy of having to have input whether we want to or not. I really appreciate your observations, Commissioner Sabone, and need them. Rely on them heavily because of your prosecutorial experience. I also think we all, universally, even with not hearing from everyone, that we sympathize and regret the impact that this ordeal and that Mr. Latbala's actions had on these women. So regardless of how this vote turns out, I think that the record has been made clear that the egregious actions were committed, and it's in the report of investigation. And if it doesn't go forward, it's strictly because of the vital testimony of two women who have testified in some form and made their experiences known, and the Senate responded, the Ethics Commission responded, albeit over a period of time that has made it further punishment for these women. Ultimately, that is not the responsibility of the commission. It is the responsibility of the person who committed those actions. And I express that because I think it's probably both in the hearts and minds of the people that sit here and the people we serve.
Okay, there's a motion to adopt the recommendation. Is there any further discussion before we take a vote? Okay. All in favor of accepting the advocate's recommendation? Say aye.
Aye.
They're all opposed?
No.
No.
The motion passes. Okay, and because the commission has granted the advocate's motion to dismiss, the complainant's request to withdraw the complaint is rendered moot, so we will move on to the next.
Madam Chair, can I have
Yes.
one PS? It won't change the outcome of anything we just discussed, but it was probably one of the more important things that I relied on, and I, again, just feel like it's important for the record, if nothing else, and that is that it was through the request of their counsel that they requested to withdraw, and to me, that was extremely meaningful.
Okay. Moving on to item number 8. We've got consideration of final action and complaint number 21-229 in Ray Eddie Martinez. This matter is before us for a final hearing because it appears there are no disputed facts. The complaint has been referred to DOA for hearing, but the administrative law judge sent it back to us after the respondent did not dispute the facts set out in the advocate's request for admissions. We have a copy of the file in this matter as well as the draft final order prepared by our staff in the advocate's motion. This hearing will be conducted pursuant to sections 125.69 and 125.7 sub 2 Florida statutes and Rule Chapter 28-106 of the Florida Administrative Code. At this hearing, we'll resolve any disputed issues of law and, if a violation is found based on the facts admitted, we'll determine what penalty is appropriate. Both parties will have an opportunity to present to the commission any oral or written evidence relating to the complaint. If a dispute of material fact is asserted during this hearing that was not admitted before DOA, we can refer the complaint back to DOA for hearing. Each party will be given 10 minutes to present arguments, starting with the advocate. Commission members may raise a question at any time during the proceeding. Only testimony and evidence relevant to the complaint will be allowed. Before we begin, are there any members who have a disclosure to make? All right, Ms. Hadley, you're recognized.
Melody Hadley, Commission Advocate. Respondent served as a member of the Monroe County Commission. As shown in my written motion to render final order, the evidence reflects that respondent violated Article 2, Section 8 Florida Constitution and Section 112.3144 Florida statutes by filing an inaccurate 2020 CE Form 1 full and public disclosure of financial interests. It has been deemed that respondent has admitted that he failed to disclose assets, liabilities, and a source of income on that form. In my motion to render final order, I'm requesting that the Commission ratify and adopt the Administrative Law Judge's July 28, 2023 order closing file and relinquishing jurisdiction. I ask that the Commission find a violation of the said Code of Ethics law and that the Commission enter a final order recommending public censure and reprimand and a civil penalty of $5,000.
Any questions for the advocate?
Move approval. Second.
right, all in favor? Aye. All opposed? All right, motion passes. Okay, item 9 is consideration of the Commission's 2024 legislative recommendations. This is a continuation of the 2024 legislative recommendations from the July 28th, 2023 meeting. Before we begin, are there members of the public present who wish to speak on this matter? Okay. It's up to you. Since we have some new folks, I think it probably makes the most sense to do what we did last go-round and go through briefly, if you could walk through them, Ms. Stillman, and then maybe at the end of that, if there's questions, discussion, and we can just see where to go from there as far as moving or adopting anything.
Okay, thank you, Madam Chair. I will be brief since we did this last time, but for benefit of our new members, kind of walk through this legislative discussion, and once you adopt whatever your legislative recommendations are for the coming session, unless there's objection, Steve and I, who function as the Commission's lobbyist in concert with any members who are helping us along the way, we will advocate for these recommendations on your behalf. The first items that we'll talk about were things that are carryovers from previous years. We did have a good legislative session in 2023. A number of the Commission's recommendations were passed into law passed in a bill by the legislature and signed into law by the governor. One of the things that was not included was a longstanding recommendation regarding 112.313 sub 7. This law prohibits an official from having a contractual relationship with a company or an entity that's doing business with the official's own agency. So a councilperson A cannot contract with business B if that business is doing business with his or her city. But if that councilperson creates A Incorporated, that corporation could do business with business B without violating the law, even if Corporation A, Inc. is solely owned by the councilperson. The Commission in the past has seen this as thwarting the underlying goal of the law to prohibit these types of conflicts, and so the Commission has recommended that loophole be closed. We have seen variations of language on this particular fix in the past, but nothing in this last session, excuse me. As to the voting conflicts law, in a nutshell, there are local requirements, two different local requirements for voting conflicts. If you're an appointed member of a board, you have to disclose your conflict prior to any participation in the matter. You have to file the form and announce your conflict to the body that you were before. If you are an elected local official, you can participate in the measure in which you have a conflict. You merely have to announce that you have a conflict, abstain from the vote, and file the form before participation. The Commission has recommended that elected officials go by the appointed official requirement, which is to make that disclosure prior to any participation, because as the law is written now, somebody can make every effort to persuade prior to coming to a vote and making that announcement at the last minute. The Commission has also asked that the legislature make the same requirement for state-level officials, so there would be consistency.
Will this remedy the situation we had of the gentleman that was serving two masters? He was on a HOA board, he was an elected official, and the problem that we had was remedy. I know it came out because of that, but would it remedy that?
Through the chair, the voting conflicts fix would not remedy that. That was a conflicting employment contractual relationship. The voting conflicts law, when they properly announce, abstain, and file the form, remedies their voting conflict only. It does not remedy a subset conflict. The next one on the list, and this was, I believe, new last year, were some whistleblower-like protections for ethics complainants. As you know, filing a complaint is a citizen's responsibility in this state. The commission cannot initiate its own investigation, and the commission in the past has believed that the threat of adverse employment or personnel actions in retaliation for a person's filing an ethics complaint discourages the filing of valid complaints. And so the commission has asked to see protections or remedies similar to those in the Whistleblowers Act for the benefit of ethics complainants. As we say, we don't necessarily need more complaints. We maybe need some better complaints, some things that are out there that people are maybe afraid to file. Per your request at the last meeting, there was language included with this packet. You wanted to see what that language might look like. So possible language is in there for your consideration and discussion. We've not seen any bills with this recommendation included. In addition to those items that were carryovers.
Commissioner Newton, did you have a question? Sorry about that.
In essence, not to discourage the public to participate, is there, or do we provide guidance for when a person contacts the office? I'm not sure how that works. Do we just send a report in, or do we talk to them to try to make sure that what they're trying to give us is going to be, I guess, worth following up or bringing to the commission? I mean, because obviously this is a way to vet it by offering a statutory requirement through the whistleblower. But I'm just trying to figure out, is there a way for us as recipients of the public and representatives of the public to, when that public comes to us, they're not lawyers, they just see that something might not be right. Is there some way that they get guidance from the commission when they come to the office or call the office on how to do it, what to do it, and is this an actual thing? I mean, do we have that? Because I don't want to, just to me, don't like if it's going to discourage them from filing reports, keep the workload down. But I understand what we're doing, but I just want to know that we have another vehicle to help in that.
Ms. Stillman.
Through the chair, this whistleblower protection is not designed to limit the complaints that come before us. It is to provide protection to folks who might work for someone that they have seen wrongdoing and wish to file a complaint about. In general, we receive many, many questions each and every day from citizens who have concerns about officials or employees in government. We speak to them. We have a guide brochure that is in layman's terms of what the standards of conduct are. We explain to them the process for filing complaints. We will also talk to them about the different standards that the type of allegation that they have might, the different standards that might be applied, or tell them if really it's not something that falls within the commission's jurisdiction. Also, with the complaint form are several pages of instruction and information about the process and what lies ahead. So we're always available to complainants and respondents.
I just didn't want to see our legislative recommendations that we're trying to, because you did mention keep telling the workload down, so I didn't want to think this is a deterrent.
No, what I meant to say is the volume of complaints is not as important as the quality of the complaints that we get. We take all complaints that are filed that possibly allege a violation of the code, and they work their way through the process by rule and by statute.
But even under this, my concern is that it's people out there that don't want to, they're already afraid for losing their livelihood or whatever. And I don't want them to perceive this as, if you try to complain, it'll make it more difficult. And I'm not really worried about the volume. Well, I am worried about the volume, but if people have a problem, then I got a problem as a commission. That's all.
This is a protection for those people who are afraid to file.
I'm speaking to the volume. Frame the volume. If you got a problem, contact us. That's all.
Absolutely, Commissioner. They do. And as staff, we don't encourage or discourage the filing of a complaint. We just provide information.
Did you say there was draft language somewhere for this? Because I don't see it on mine. Is there somewhere I can find that?
Yes, there was draft language sent in the packet. Yes, there was subsequent email. We can see if we can get some printed out if you all need additional copies. Lynn, would you facilitate that?
Is this something we're voting on to move forward today?
Yeah, so I think maybe, potentially. So I think maybe let's go through the summary, and then if there's questions on specific pieces, let's have a discussion at the end, just to keep things moving.
Okay. The next item that came up dealt with a cost and attorney's fees petition that was before you recently. That cost and attorney's fees petition was filed by a candidate. During that process, when you were reviewing it as to whether or not you could send it to DOA, it was determined that the cost and attorney's fees provision in the law as currently written did not give candidates the ability to pursue costs and fees. They're exonerated from a complaint. I believe it was maliciously filed. So the commission had requested that this be added as a part of your consideration for legislation, where that section of the law would be amended to allow candidates to pursue a cost and attorney's fees matter should they have a complaint filed against them, and their petition meets the criteria. Another addition was a staff observation for a technical change. We would ask that the commission consider a recommendation to amend the law to clarify that individuals appointed to complete the remainder of a term of office for a Form 6 filer are required to complete the Form 6 disclosure so that there is not a gap in disclosure of financial interests. Another staff observation that we caught was when the legislature accepted the commission's recommendation to increase penalties for ethics violations from $10,000 to $20,000. We noted that the in-office and post-office lobbying restrictions that were recently enacted do not rely on Section 112.317 for penalties, but instead rely on a different section of law. And since 112.3122 has its own penalty provision, which includes civil penalties of up to $10,000, you might want to consider amending it to comport with the penalties in 317. We also have, finally, in terms of recommendations, was something that came to us from the advocates. The advocates have requested the ability to utilize salary withholding when they're seeking collection of a civil penalty that has been imposed in relation to a complaint violation. Salary withholding has been a good tool for collection of the automatic fines that people accrue for late filing of financial disclosure, and the advocates would appreciate having that tool in their toolbox so that they have something other than just pursuing a judgment in court. So that completes the list of recommendations. If you want to work through those, in addition to that, in the past, you have opposed certain types of legislation that has come up. In the past few years, we've included those with our recommendations. We've included the opposition. We haven't seen those types of bills come up. So whether or not you want to put that with your package at this time or hold opposition to things in abeyance until things are happening. One disadvantage to that is, as you know, session moves quickly. The commission only meets every 6 weeks or so, so it can be challenging to turn on a dime when something might weaken the ethics law, and so that's something for you to consider today as well.
Okay, so I guess I'll kick off the discussion. I think the draft language, and I suspect that some of the new folks are having the same issue that I had last meeting, which is talking about legislation that we either are in favor of or oppose without having a sense of the background that led to it, not seeing any draft language. And to that end, I really appreciate the addition on the whistleblower The
Just want to make sure, was that circulated?
It was circulated via email, I believe. I think that it would probably be beneficial if it's possible to get those hard copies now. But the draft language was circulated, and I appreciated that. And my personal view is that I'm comfortable voting to recommend something that's got language attached to it. Less so, not saying these aren't, fine ideas, but I think that my personal view would be to, move forward if we have recommended language, but if we're just talking in the abstract and there's no recommended language or an actual bill that's been proposed, I would vote to, I would like to take that off the plate of our recommendations. Please.
The process, and Senator can probably comply with that, because we participate in that process of how a bill becomes a law. These are recommendations to the legislature. Through the committee process, this is going to change. That's why they work hand in hand with the legislatures throughout the session to try to get the final thing through. If and when it passes off the House floor and off the Senate floor, it has to go to the governor's desk, and the governor has to sign it. He can let it become law without signing, or he can veto it. So what I'm getting at is that language, while it may be vague at best, it does report the statutes, but it may be some opposition, some changes from different members and things they want in there to gain their vote. So what we often see at the end product, might not be what we're looking at now. That's all, just sharing that process.
Sure, and I'm fairly familiar with the legislative process, but I'm also a lawyer, and I like to know what the words on the page say, not what somebody thinks the words mean. And so that's why I'm kind of a stickler for seeing actual language, knowing that it's subject to change. But that's only my personal view, and it's open to all of these items are obviously open to discussion by the rest of the commission.
Well, we just said, like I said, we send our bills, we send them the bill drafting. It's not an idea. It becomes a law, and we have to and then they have to narrow it down to what's feasible. Does it have a physical impact on the budget? Stuff like that. All that's is being considered. So I was just saying that the end product might not be what we're looking at here today, and that's why our staff works with them throughout the legislative session and committee session to try to get, something that we need to have some teeth in it, if you will, in the end, if and when the government signs it. That's all I can really do.
Did you want to make a comment on the whistleblower language?
Yes, she's making some additional copies of the whistleblower language that Steve did prepare, so you will have that. In the past with commissions, when we've provided language to commissioners, it has been past commissions' sentiment in the last few years that they did not want to presume to tell the legislature how to draft it. So that's why we didn't provide language for each and every one of these things to you for your consideration. We always stand ready to provide language to the legislature if they ask us to, and certainly if this commission's will is for staff to provide language for each and every recommendation. That's something we can certainly do, and that has been done in the past with different commissions as well.
I don't know that it is feasible for us to try to limit ourselves to specific language right now for the very reasons that Commissioner Newton was talking about. I think we have to start with concept, and then we have to see through the legislative process what gets drafted, what needs to be added, deleted, all those things that happen down at the Capitol. Concept is the only way to start. I just think we're putting the cart before the horse. If we look too far to specific language, would put ourselves in a position where would have to constantly be trying to change a specific word or phrase. We can't do. That's what they do in the Capitol building.
So if I may, as someone who sat on a board who has had to come together and get our lobbyists to go to Tallahassee with our agenda before, you're absolutely right. If we never drafted language and sent it up, we pretty much bulleted out what we needed from our school board, basically, in education, and sent our lobbyists out with the permission to clarify our intent as needed. And so as someone who's new here, I'm just going to go with you guys because I don't know what we need from here to move through. You guys do. So I'm on board. If we were voting on specific language, I just wanted to have the language in front of me so to make sure there wasn't anything glaring that jumped out at me.
Madam Chair, the question for staff, will we not, if the committee bill emerges or member files a bill related to any of these items, will we not be presented with those bills to review and comment on at some point in time between now and end of session?
Through the chair. Generally speaking, you
As-
all don't meet
As time allows.
frequently
Yeah.
enough during session to see those bills and discuss the language. And so, Steve and I often work very closely with House and Senate staff when they are drafting to make sure that what the legislature is trying to do is actually going to be what is in terms of implementation and the language they're using, or if they're seeking to implement your recommendation, that the language that they're using does do precisely what it was you're recommending.
Follow up?
Sure.
Who then speaks on behalf of the commission? Just the two of you, or?
Through the chair. Steve and I do attend the meetings. We do speak on the commission's behalf in terms of your recommendations. When they are in bills, we support those things that are your recommendations. When there is a bill that has language that affects the ethics laws, sometimes we do not speak unless there are maybe some implementation considerations, where then we speak to the legislature. I cannot tell the committee or a senator or a House member that the commission supports or opposes something unless you all have actually indicated your support or opposition. So obviously your recommendations you support. If you haven't met to oppose something, I cannot say that you oppose it. And obviously I will staff closely if there are concerns. I might say, not sure how my commission is going to feel about this particular aspect. When there is an opportunity, if we were to, we've tried before to have legislative meetings, there are notice requirements that are in place for this board, and getting everybody's calendar together and getting to move quick enough to the pace of the legislature is sometimes difficult.
Thank you, Madam Chair. This is, in effect, a new board, and it can make its own decisions about how to proceed. It has been helpful in the past, and I say this having served on the legislative side as well as on this commission. It's been helpful in the past, and it's been a practice in the past for the chair of the commission to be a spokesperson on behalf of the commission. As my colleague here correctly pointed out, the legislative process moves rapidly and does not necessarily move logically. And so consequently, there are times when somebody has to say, yeah, we can live with this, or no, we think we got a problem with that. And we have in the past deputized and given full assurance on behalf of our chair to go forward and speak on behalf of the commission. And obviously the chair operates with discretion. You're not going to come back with a code of ethics that we've never heard of before. But I think that's the appropriate way to proceed, because if all you do is sit mutely, the legislative process rolls back and forth, then you sort of get what you deserve. So my recommendation and my hope is that from a technical standpoint, that our executive director and general counsel are there to work with committee staff on language and on indicating how the commission operates and what kinds of cases we've had before us, and why certain language may or may not be helpful. But if it's necessary to have somebody sit down with the Senate President or sit down with a House Speaker or a committee chair and say, yes, we like this, or no, we don't like that, yes, I think our chair should do that.
Second. Oh, I thought you were making a motion.
I'm making a suggestion.
And I assume I know the answer to this, but are there any pitfalls with lobbying the legislature? Try to not do it.
Speaking from experience, you won't be compensated for the lobbying.
Well, then,
So you're free to assist us, and
okay.
your help would be valued.
Okay.
I think, if I may, Madam Chair, our executive director, she's been excellent. All I get is updates through the legislative session almost every other day on how there was a movement, which ones are doing what. I mean, I've been getting that. I know some of them is new to the team. She's very good at communicating what's happening with stuff that we recommended that's moving. Again, you have 120 representatives, 40 senators, and you got executive staff and the governor. If one thing in there somebody don't like, it'll die in committee, it won't move, or, I mean, all of our stuff, all of the executive director testify this, how much stuff have we recommended that didn't go nowhere, that they didn't want to even touch? And he's right, the Senate President, the Speaker, they may see stuff they don't want to even bother with. They may say it's okay the way it is, why are we messing with it? So they have to just work with them. The working relationship, a cordial one, is great to make sure the stuff makes it out of committee, makes it out the House floor and the Senate floor, and gets to the governor's desk and with some income. That's the only way we're going to be able to do this. But it's how, and it's a concept, how, like the gentleman in said, it's how a bill becomes a law. And it will be a lot different because you're going to have members that don't like this and don't like that.
Okay.
But we're creating ethics system that they're governed by them and all of our public service individuals. So you got 120 members that probably ain't gonna like what you're trying to do because it's gonna affect them too. So I'm just saying, keep that in mind as we make recommendations to the legislative body. That's gotta go to the executive.
We did
Right.
work closely with the chair and vice chair this past session.
Okay.
To move the bills.
All right. Commissioner Gates, were you going to make a motion, or was there a motion?
I'm simply making a suggestion. I think this commission, functionally as a new commission, should decide how it wants to proceed. I'm only saying that having been a Senate president and been a committee chair, when a commissioner comes in the door, who's been appointed by an appointing authority, that carries weight. And it adds to the quality that our executive director and general counsel have been able to place behind arguments. So all I'm saying is, however we do and discuss and develop a legislative agenda, I think our chair should be empowered by this commission to speak on our behalf.
Do we need a motion on this?
I so move.
Okay, all in favor?
Aye.
Aye.
Just to clarify the motion, I love that it identifies the chair as one of our advocates and lobbyists with respect to the commission agenda, but are we, with that motion, adopting the recommendations that were included in our packet as our legislative proposal?
Madam Chair, no. My motion was simply as to a process for articulating our legislative package, whatever it might be.
Well, I will move acceptance of this agenda as our starting point.
Second.
Well, right, so let's take this one at a time. So the first motion was regarding deputizing the chair to participate, and that was seconded. All in favor? Aye. Okay, that one passes. Next was the motion to accept this as written.
Yes, as our starting point agenda.
Okay, as our starting point agenda. Is there a second to that motion?
Second.
Okay, all in favor?
Aye.
All right, that one passes as well.
Last year, the chair and vice chair worked on the commission's behalf. Are we going to have more than one commissioner, or are we going to move forward?
I'll make a motion.
Okay, what's the motion?
I'd like to move as appropriate and honoring the sunshine laws that obviously apply, that the vice chair also be included when appropriate in helping with the legislative process.
Second.
Great, all in favor?
Aye.
I tried to kick you out of that job earlier. It didn't work.
We're almost to the end of it. We're down.
Oh, it's my fault. It's my fault it's taking so long.
No.
Got that very good already.
All right. Last, item on the agenda is reports. And I can tell you that there is no chair's report. Is there a report from the executive director?
Yes, through the chair. You have my written report, but in addition to that, wanted to introduce a few new staff members to you. First, I'd like to officially welcome Brandon Garner to the commission. He joined our staff as part of our administrative support team back this summer, and it was trial by fire with disclosure season, and because things have been so hectic, we've only now let him out of the office to come to a commission meeting. And he's the pleasant voice that you often hear when you call the commission. He's also learning the disclosure system, and we're very happy to have him. Also, originally joining us as a part-time OPS financial disclosure clerk, we liked him so much we hired him on as a permanent part-time clerk, is Jeremy Pennington. And so we're really glad to have him. He's been already making an impact, and he works very closely with Millie and complaints as well as any other support that staff might need. A couple more. A lot's been happening. I'm happy to welcome back Bob Malone to the investigative staff. He fills a recent investigator vacancy, and he brings more than 30 years of investigative experience to the job. We're thrilled to have him back with us, and I know he's going to help us keep things efficient as an investigator and a part of that team. So we're glad to have him back. And then finally, last but not least, our commission advocates have recently hired a new legal assistant to join them. That's Victoria Johnson. They're in the front row, and she's been getting wonderful reviews, and I know they are thrilled to finally have you with them. So welcome to the commission to all of you. Okay, and with the chair's indulgence, I will move on to the e-filing report.
Madam Chair, if I may, before we get to e-filing, I could just make a comment as to the executive director's report. This has been an interesting time in the history of our commission. It's been an unprecedented time. We've had the resignation of the chair in the middle of the term. We've had 4 new commissioners in 2 meetings, which is a lot of change, more change than this commission has been used to, and I welcome those refreshing new voices. But I want to, I'd like to point out in the context of the executive director's report that in some of the issues that have come up, some of them have gotten in the media. The Ethics Commission's staff, particularly our executive director and our general counsel, have carried forward in a highly professional manner. They have represented themselves and this commission without fear or favor with respect to the unsettled issues that have come forward and been settled. And I'm very proud of them, and I support them. And I believe that the commission and its work is ennobled when you have an outstanding executive director and an outstanding general counsel who go right down the line and operate in a fair and even-handed fashion with everyone who comes before the commission and with the business of commissioners themselves. So I simply wanted to thank our commissioner, our executive director, and our general counsel in the context of the executive director's report.
Second that.
It's primarily on the legal staff. That's what I really been following and spend a lot of time with. No matter the opinions or whatever you go to our legal, it's always codified in statute. So interpretation is always to the law. And they put it out there for you to read it. You might not like what it reads, but this is what it is. This is what you signed up for. And I never seen one way for not one momentum. And I appreciate that. I do. But sometimes when I was serving in the House, we get into trouble. I say we need different branches of the government, like the judiciary, the legislative, because they try to legislate from the bench. They try to change laws and statutes within the power that they really don't have. And that's what gets us in a lot of trouble. But I always, no disrespect to none of them, but you always see me direct to legal, because this is the gentleman that keep me out of the weeds. So I always say, if I can get the pen. Because you're going to get your chapter and verse. You might not like it, but that's what's been codified, that's what's been signed into law, and that's what it is. And I like it, because he's consistent. I've never seen him waver not once. Even if you don't like it, it's the law. So I want to thank you for that and your staff, because I follow some of this stuff, and that's all I was reading. Law said, law said, law said. Thank you.
Go ahead. All right, so on to e-filing, everyone's favorite topic. We've just completed our first full e-filing season for Form 6, and as I mentioned at the July meeting, the process for filers has been very smooth based on the feedback we've received. There were 1,377 Form 6 disclosures that were filed electronically for Form 6 officials. Currently, only 15 of those filers have not yet filed with my math calculations, which are hopefully right. We're sitting around a 99% compliance rate there. Automatic fines began accruing in the amount of $25 a day for each day late. Anyone who hadn't electronically filed by before midnight on the 1st. Weekly emails are being sent from the system to the filers who have not yet filed, urging them to file and advising them that fines are accruing. As for judges who are not subject to the Commission's jurisdiction, we are the repository for their forms. There were 1,205 judges who filed the Form 6 electronically. That includes senior judges as well, with 19 yet to be filed, which is about 98.5%, I think. And then while we're talking about compliance, I don't want to leave out our Form 1 filers, which were still being filed on paper this year. Filed with the Commission were 12,671 Form 1 disclosures. Those were filed on paper by state filers. Only 150 state filers have yet to file, so we're again sitting at nearly 99% compliance. As to local filers, there are 22,096 filers at the local level who file with the 67 supervisors of elections. 553 of those have yet to file. That's about 97.5%. Those numbers will go up. More officials will be filing because we hound them about it. And to that end, in addition to the statutory requirements of notice and all of the different things we have to do, there's something we do each year that is not required by statute, among numerous things that we do. But on August 25th, we had our annual Phone Fun Day, which is a day in which every member of the Commission staff endeavors to call as many disclosure filers as they can in a given day. It's a friendly competition with at no cost to the taxpayers, a couple of prizes, and we try to reach as many of these filers as we can to urge them to file before that filing deadline starts. It's not mandated by statute, but we do it. We would rather get folks to comply and file than fine them and deal with them on that end. So the goal is compliance. We placed 562 calls. We contacted all Form 6 filers, calls and or email, as well as state Form 1 filers and a number of the local filers, as many as we could get to. And those efforts are helpful in getting people to file in that last week. So moving back to electronic filing, we now face the launch of Form 1, January 1 of 2024, in e-filing. And all of those local filers and all of those state Form 1 filers, they're all coming into the system. At that same time, those city commissioners and mayors will be moving to Form 6 and filing electronically. So also launching, in addition to Form 1, will be the Form 2. And we're now in user acceptance testing of that system for Form 1 and soon to be Form 2. There are 3 phases to that testing. And without boring you, I'll let you know that those began last week. There'll be another in October, another in November, and the UAT testing ends in December. Kim and Lynn are critical to that process. They were critical to the process for Form 6. They will be embedded with our IT folks downtown for a number of hours during these testing periods. And there is always a flurry of activity related to e-filing. So we're also working to determine January to March qualifying periods, which offices are going to be qualifying when, so that we can make sure that we're pushing the invitations to register to anyone who is a current filer, so that there are not any hiccups in that qualifying process, working with the League of Cities, working with city clerks, working with the elections officials to make sure that all of that goes smoothly, as well as our staffing, communication, and training plans for that rollout. And that concludes that.
You say that the staff made 600 and some calls to the individuals to remind them to file a report. Do we have access, and can we use SMS and text messages?
That's a good question. Through the chair, we don't currently have that ability with our filers. That could be something that comes as we move through the implementation of the e-filing system for everyone. We'll have almost 40,000 filers. The law requires email notifications. That doesn't mean that we can't do other things. The current system, however, is not set up for that. We would have to look to our IT folks who are contracted to handle this down at OLITS in the Office of Legislative Information Technology Services to see what something like that would entail, how much additional time would be needed.
The reason I put that out there is because we, if we're stuck in a committee or meeting or can't answer a voicemail or answer the phone, the texts pop up. And also, I don't care how many texts you got, the last one you got was 6 So it's just a mental thing. Someone can't even do that, and they'll probably jump in on it. A lot more people respond to texts than phone calls and emails. Just a suggestion. Just throwing it out there.
Thank you for that. We will, Lynn and Kim will make sure that we ask the right questions and try to work something like that.
Just sound like the phone numbers.
Often the phone numbers we have are office phone numbers. It's what is provided to us.
Great work.
All right, is this for
Yes,
later?
just for-
Okay. All right, is there a motion to adjourn? Second. All in favor? Aye. Have to physically bang the gavel.
You can stand it.
They got chair.
I'm sorry.
But I will insist that you take your purse. I'll take your seat here, but I won't take your purse.
It matches your suit.
We were ethical, but we already went through it.
So is this just for my
This is
FYI?
just to let you know.
Okay.
He had travel, so I wanted to make you aware when he gets up and leaves during this.
I won't.
Through no fault of his own.
I won't chase him out of the room and drag him back.